colleagues, friends. Professor Trunk's kind invitation to contribute to this conference by offering a few of my personal recollections of Professor Boguslavskiy was gratefully accepted by me. Being only 9 years younger than Mark Moiseevich makes me one of the few people in the field of the study of Soviet and Russian law who had the opportunity of having been involved in many of the activities in which he played such a prominent part. At the end of his remarkable career, he looked back on it in a delightful little book, Witness of an Epoch, Svidetel Epochi, published in 2008. Reading this book again and combining it with my contacts with the author over a number of years prompted various thoughts which I would like to share with you today. I'm in no way qualified to appreciate and judge the achievements of Professor Boguslavskiy in the areas of his special interest: private international law, international business law, the law of intellectual and industrial property, to mention the most notable among them. The reason for this, and it applies to most Western colleagues of my generation, is that our interest was primarily focused on towards those aspects of Soviet law which were fundamentally different from Western law. That's to say, mainly constitutional and criminal law. In the more practical and technical part of private law, Soviet law actually had very little of interest to offer. A certain amount of information and knowledge was required in the West in connection with actual business contacts. Civil law was only interesting in areas where there were important differences. The law on real property, for instance, because everything was in principle owned by the Soviet state, or the regulation of economic life, where the planned economy presented an imitation of a market economy, although all participants were state enterprises bound by state planning. Universities also consider, and quite properly, the interests of their students and of society in general, explaining to Western law students that Soviet tort law was not so very different from what they were used to at home would not do much to increase the popularity of Soviet law to a young audience. In those days, we understood quite well that technical aspects of private law, well, just like legal history or linguistics, were safe fields for Soviet scholars, provided they began their works with 2 pages of obligatory references to the Osnova Položniki, the foundation layers, Marx, Engels, Lenin, and Stalin, the latter only until 1956. The natural sciences were on the whole mostly free of these ideological restrictions. Mark Moiseevich, quite early in his career, made a sensible choice of going for a life in conducting research where he was relatively free and could make a meaningful contribution. Not an exaggeration to state that Professor Boguslavskiy put his most beloved subjects, private international law and the law of intellectual and industrial ownership, on the map of legal studies in the USSR. He did this by writing or co-authoring major textbooks and fundamental studies, as well as by lecturing incessantly to a variety of interested audiences all over the former Soviet Union and in many countries of East and West. His success was also due to his personality, friendly and cooperative, always searching for common ground. His autobiography, which I just mentioned, painted a lively picture of his activities all over the world. As to his own country, he entertained his readers with wonderful stories about the dealings and friendships with generations of legal scholars from Russia itself and many other countries of the former Soviet Union. His own peaceful and accommodating attitude inspired his generally friendly comments and the praise he heaped on many of his colleagues. Like a few others of his generation, he was in the fortunate position of having been taught by scholars who made their careers in Imperial Russia and then acted himself as the teacher of a new generation which had itself little or no experience of what it meant to live and work in Soviet times. If one reads Professor Boguslavskiy's account without any previous knowledge of Russian and Soviet history and the way it affected legal studies, one gets the impression of the story of a natural and more or less harmonious progression in the span of 70 to 80 years. This is one aspect of the approach of the author that puzzled me. How could a highly erudite and well informed observer, whose father perished in the Gulag and whose grandparents were shot at Babi Yar, speak complacently about Stalin and his numerous supporters also among the ranks of legal scholars, steering completely clear of any negative comments? He does indeed mention that he was never a member of the Communist Party, but that is about all. I could only reach the conclusion that his curious silence in this matter was the result of a conscious decision. But as he passed over the entire problem itself, we are left to wonder about the reasons for this decision. There are many scholars from the Soviet academic world who adopted a different stance. I only have to mention world famous figures like Sakharov or the literary historian D.S. Likhachov. I do not have the right to judge in this matter, but I thought it would be appropriate to add this question mark to my otherwise warm appraisal for the achievements of Mark Moiseevich and my fond recollections of our personal context. Thank you.